Good morning, and thank you for joining me on the Path to Liberty. This is the Fast Friday edition of the show for May 14th, 2021. And today I'm talking about qualified immunity, the legal doctrine created out of thin air by the Supreme Court and then forced on all 50 states. This is legislating from the bench at its absolute worst. Yet there are a lot of people who claim to support the Constitution who absolutely love this doctrine. So on this episode, I'm going to quickly go through what I see as the top 4 lies or misrepresentations that I hear in support of qualified immunity and give you a brief response to each. But first of all, before getting to that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. Our show homepage has everything you need to follow this program, all the archives on individual episodes. I link to a bunch of stuff that I talk about so you can read and learn more on your own time. You can see all the different platforms we're on, both video and audio-only podcast edition, and even our membership program where you can put your financial faith behind our work for as little as $2 a month, and we make it go a long, long way in support of the Constitution and liberty. That show homepage is 10thamendmentcenter.com/path to liberty. It's all spelled out, 10thamendmentcenter.com/path to liberty. And I couldn't be more grateful for you spending some of your time with me today. Thank you so much for being here. Whether this is your first episode or you've been here for every single one since day one, I honestly don't even know if I've been here for every single one since day one, but I can't thank you enough for spending some of your time with me today. But since it's Fast Friday, I promise to not take up too much of that time. Let's see if I can get this info out to you in the next 10 to 15 minutes. And I'm not going to really go into detail about the history of qualified immunity, what it is, and all that stuff. I've actually covered that in a number of episodes, and I want to pull up this one on the screen here. I will link to this in the show notes, 10thamendmentcenter.com/path to liberty, so you can learn all about the history and how it plays out, which is not good. How federal courts gave us qualified immunity and forced it on all 50 states is my best recommendation for an episode I've done on this. This was in June 17th of 2020. And with that, let's get through these top 4 questions that we hear all the time. The first one, or the lies, misrepresentations, not really questions. Number 1 is you don't need to get rid of qualified immunity to successfully sue the police. And I want to start out with Institute for Justice. They point out very rightly that this isn't just about cops. They point out that the doctrine shields more than just police. It protects all government workers from constitutional lawsuits. And again, Institute for Justice says QI, a qualified immunity, grants all workers for the government immunity for violating constitutional and civil rights unless the victims of those violations can show that their rights were, quote, clearly established. This is a legal test. It's a very high bar, and they put it this way. Although innocuous sounding, this clearly established legal test is an obstacle nearly impossible to overcome. It requires a victim of government abuse. That sounds like it's pretty redundant, government abuse. It requires a victim of government to identify an earlier decision by the Supreme Court or a federal appeals court in the same jurisdiction, holding that precisely the same conduct under the same circumstances is illegal or unconstitutional. So unless you've had the exact same scenario in the past held by a court that said it's unconstitutional, it doesn't matter how bad it is, qualified immunity protects them. And that's what IJ says. If none exists, the government worker is immune. It doesn't matter whether the worker's actions are unconstitutional, unreasonable, intentional, or malicious. In other words, the doctrine, you absolutely do need to get rid of qualified immunity to really have a chance beyond a needle in a haystack to be able to successfully sue a government worker for violating your rights under the Constitution, whether it's under the state or the federal Constitution. Number 2 comes from Jay Schweikert over at the Cato Institute, and Jay does great work on QI. And he's got his own list of common we'll call them lies. I don't think he uses that term. He says eliminating qualified immunity would negatively impact recruitment and retention of police officers because they would fear being sued. So we hear this over and over and over. There's going to be all these frivolous lawsuits, which I'll get to in a little bit as well. So then law enforcement won't be able to do their jobs. They're always going to hold back and crime is going to run rampant. Of course, fear is the foundation, as John Adams put it. You can see it here on my t-shirt, a nice 10th Amendment Center product, of most governments, Adams put it. I would only disagree with him. You've heard me say this over and over on the word most. Just get rid of it. And fear is the foundation of governments. Here's how Jay put it over at Cato. He says, even in the absence of qualified immunity, it is by no means easy to demonstrate that a police officer violated your constitutional rights. I don't like the phrase constitutional rights, but anyways, our Fourth Amendment jurisprudence incorporates tremendous deference to police decision-making, and officers who genuinely make reasonable, good faith decisions about arrests, use of force, are already protected from being sued. So even without qualified immunity, it's incredibly difficult to win a lawsuit against a law enforcement officer for violating your rights. And he says, the idea that eliminating QI would somehow lead to ruinous lawsuits anytime someone disagreed with an officer's use of force is reckless, inaccurate, fear-mongering. Again, using fear to give government power to be able to do whatever it wants, arbitrary power without any recourse whatsoever. He goes a little further. He says, additionally, police officers are nearly always indemnified for any settlements or judgments against them, meaning that their municipal employers, not the officers themselves, actually end up paying. So if you sue the government and you actually get to win, it's not like the dude who violates your rights is going to pay anything. Probably get some paid leave, but you're going to get paid out of the taxpayer dollars. Anyways, this is a study from UCLA from Joanna Schwartz. She said this is in 2014, governments paid approximately 99.98% of the dollars that plaintiffs recovered in lawsuits alleging civil rights violations by law enforcement. And Jay says, in other words, even when plaintiffs do overcome qualified immunity, which doesn't happen too often, the individual officers rarely pay a dime. So they're not going to be concerned about this. Is just garbage lying all around. And then he goes on, and this is a good summary of this one. He says, nevertheless, as things currently stand, individual officers are almost never required to pay anything, even when they have are found to have committed a constitutional violation. The immediate effect of eliminating qualified immunity would not be to subject those officers to huge judgments, but rather to ensure that victims whose rights are violated have a remedy. And that's a real important thing. I will get to that right at the end. Institute for Justice has some great stuff on this. Number 3 is also from Jay Schweikert over at Cato. And I apologize, Jay, if I get your name wrong on this, but a great article over at cato.org, which of course I will link to in the show notes. I'm only covering a couple of the ones that he lists. And he points out, again, this is on lawsuits. Qualified immunity, we hear, is necessary to prevent frivolous lawsuits against police officers. We hear this all the time when we're supporting legislation in the states to end qualified immunity or to literally just create a process in the state to be able to sue under the state constitution rather than creating a federal situation out of anything and everything. And he does point out that there are really 2 types of frivolous lawsuits. I'm not going to get into much detail, but basically, one is that there's no legal merit. So the argument in that situation that you make is true, but it's not, what happened really isn't a constitutional violation. So it's considered frivolous. Or there's no factual merit. So you're definitely in that situation talking about an actual violation of someone's rights under the Constitution, but you're either mistaken about the facts of what happened or you're lying. And I think they're mostly using the fear about people just lying and saying that a cop did this, and they're not even talking about all government officials. Remember, this is, again, a situation where all government officials are protected. They're given almost near total sovereign immunity, even though it's called qualified immunity. And here's how Jay puts it. Qualified immunity does basically nothing to stop frivolous lawsuits because The doctrine only kicks in when the underlying lawsuit is meritorious. So if there's no merit to it, whether there's no legal merit or no factual merit, it doesn't even get to the point of an immunity question. So it doesn't even get brought up. So qualified immunity doesn't prevent frivolous lawsuits. And that's how Jay sums it up. The idea that eliminating qualified immunity will result in a wave of frivolous litigation is more baseless fear-mongering. Qualified immunity does nothing now to prevent such litigation, so we shouldn't expect a major change in this regard if the doctrine gets abolished. And then number 4, the last one that I'm going to cover, is basically that qualified immunity is a long-standing part of American law and tradition. And in fact, the Major Cities Chiefs Association, this is an organization representing, I think, somewhere between 60 and 70 of the largest law enforcement organizations in cities around the country. And they put out some statements on all kinds of things trying to restrict law enforcement power that they can't stand. And one of them that they put out last June, I believe, June of 2020, they were talking about qualified immunity. And of course, the Major Cities Chiefs Association, the MCCA, strongly opposes repealing or amending the qualified immunity statute. They specifically call it a statute, as if it's some kind of federal law on the books. Either they're lying or they're just ignorant or they're just like, they don't care. They just want their people, they want their team to not ever have to face anyone in court. I think that's probably it. But anyways, they call it a statute. They never changed this. They continually call it this. And they've done an update in recent months or in recent weeks talking about it as well, calling it qualified immunity statute, as if it was something that was passed under the Constitution by Congress or in the state and created as law. But instead, it's something completely different. As I mentioned right in the introduction, this is legislating from the bench. And here from Unlawful Shield, which is the abolishing qualified immunity project from Cato, and they put it this way: the doctrine of qualified immunity has changed substantially over the years, but it was first articulated in a 1967 Supreme Court case called Pearson versus Ray. And I cover the cases and the history in that episode that I referenced right at the outset, how federal courts gave us qualified immunity and forced it on all 50 states. So Unlawful Shield points to 1967. Others, like Institute for Justice, point to another case in 1982, and this is how they sum it up. Qualified immunity is a special protection for government workers that the Supreme Court created in 1982. I think, you can put it all together. Created in 82 as an act of judicial policymaking. The case Harlow versus Fitzgerald did not even involve police, which is really interesting. It was brought by a whistleblower who wanted to sue Nixon White House aides for punishing him because he spoke out against a Pentagon weapons program. That's a hero. In Harlow, the Supreme Court made all government workers immune from constitutional liability by default. And through the incorporation doctrine, which I think is absolute junk, they took that doctrine and then forced it onto all 50 states. So now it becomes the one error by the Supreme Court in 1982, again, building off of the previous decision in opinion in 67, now gets expanded and it becomes the law, the statute, as MCCA puts it, for all 50 states. And here again from IJ, and this is a great summary. Judge-made immunities like these are inconsistent with American legal history, which shows that the Constitution is meant to provide a government that is limited in fact, not just in theory. The practice of dismissing constitutional claims on immunity grounds flies in the face of this history and is contrary to one of our most cherished legal principles. Where there is a right, there must be a remedy. Well, I hope you guys found this interesting. I hope it was educational. I hope you're interested in learning more and you check out at least that other episode. I will link to these articles in the show notes over at 10thamendmentcenter.com/path-to-liberty. Of course, if you support the show and you want to help us spread the word, please consider leaving a review on Apple Podcasts or any other podcast platform, smashing the like button, subscribing, getting notifications, leaving comments. All that stuff helps us trigger the algorithm of the platform and show the program to more people. And our membership program starts out as just at just $2 a month over at 10thamendmentcenter.com/members. Again, I really appreciate you spending some of your time with me today. I hope you enjoyed this episode. I hope you have a great weekend, and I'll see you next week here on the Path to Liberty.